Welcome, everyone. I'm going to give you a couple minutes to log in from the waiting room, and we're going to get the closed captions up and running. And if anyone has feedback about the closed captions, I am trying the Zoom closed captions this year. So let me know if they're better, worse, or the same than what I was using last year. It's definitely easier to do the Zoom closed captions, but I want to make sure it's also good quality. So welcome everyone. I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services. And I'm excited to welcome you to the first Public Interest Law Section co-sponsored webinar of this year. We're going to learn about tenant screening and the Fair Credit Reporting Act. And this was put together by the Public Interest Law Section Consumer and Tenant Protection Workgroup. So once we get started, I'll put that information in the chat in case you want to join PILs and join in on all the good work that work group is doing. So today we have with us Austin Griffin. He's a partner at Story Griffin Law Firm, and also Adam Thoresen, and he is the Division Chief of the Consumer Advocacy and Litigation Unit at Jacksonville Area Legal Aid. This is being recorded. We're going to try to hold questions until the end, but you can type them in the Q&A box at any time, and I'll keep an eye on them. All right, without further ado, I'll pass it over to Adam and Austin. Thanks for joining us today.
All right, thanks, Christy, and really just wanted to do a special thanks to Austin too for taking some time out, helping us with this important issue, and of course all you folks for being here today. You know, these kind of tenant screening cases are near and dear to my heart. It's a lot of the work that I'm doing. So for those of you that do landlord-tenant law, for those of you that do consumer law, learning a little more about tenant screening and how we can help our clients, I think is it's very important these days. So this is just some stuff Christy already covered. You know, you guys can put your questions in the chat box. I'll try to keep an eye on it as we move through this. But if not, Austin and I have reserved some time at the end to take questions, so we'll try to get to them then. Here's just really, you know, kind of an overview of what we hope to cover today. You know, first, we're going to kind of talk about just the background of the industry. What are these tenant screening companies? How are they making these reports about your clients? Where are they getting the information from? How does that information flow to the landlords? And then we're going to move sort of into the nuts and bolts of issue spotting these claims. You know, what kinds of causes of action you might have under the FCRA, maybe even the FCCPA, so the Florida Consumer Collection Practices Act, or the FDCA, which is the federal analog. And then, you know, most importantly, probably Austin is going to run us through some hypos, some real world examples about how you guys can kind of apply this to your work day to day, and then just some practical advice, litigation tips, etc. All right, so, you know, first and foremost, I'm going to kind of pretend like everybody that's here at this session is really new to this area of law. Quite frankly, I'm still learning every time I look into one of these cases or file one of these cases. So really, let's start at the basics here. So what are we talking about when we're talking about tenant screening, or when we're talking about background screening? And generally speaking, we're talking about reports generated for employment, housing, professional licensing, or other types of credit or insurance products. That's really kind of your bread and butter background screening report. And as you'll see, as we move forward, there's a lot of similarities between these types of reports. So these days, the type of report that a landlord is going to be pulling on one of your clients when they're looking at them for an application for rental, to rent a unit, it's going to be very similar to what we used to maybe see in the employment context. So these rental screening reports, they aren't just going to have information about your client's past rental history or rental debts. It's going to maybe have information about their income, their past employment. It's going to have information about their criminal history. So there's kind of a lot of overlap between these companies, between the type of data that they're using. And that's something that's maybe a little different than 5 or 10 years ago. These rental screening, these landlords are interested in a lot more about your clients than they used to be. All right, so why are we all here today? Why should a landlord tenant lawyer, why should a consumer lawyer care about a tenant screening report? Right? We defend debt collection cases, we defend people in evictions. And the main reason that we should care is that these background screening companies, these tenant screening companies, fall into this very broad definition of consumer reporting agencies. And so when you talk about the Fair Credit Reporting Act, there's kind of a tendency to think that that only deals with traditional credit reports. Cases that Austin and I might be familiar with against TransUnion or Experian or Equifax. Those are what we call the big three, kind of traditional credit reporting. But the good news for all of us that do this sort of work is that these tenant screening companies, generally speaking, are also consumer reporting agencies. And that's kind of a distinction. When I talk to people about this, they talk about credit reporting agencies. Well, the defined term is a consumer reporting agency. And these tenant screening reports are consumer reports. And because of that, they are subject to the Fair Credit Reporting Act, which is very important. And then so those are the CRAs. And then there's another very important term that we probably need to be familiar with today. And that's what we would call a furnisher, a data furnisher. So you have the CRAs, the consumer reporting agencies, and they're the ones that produce and give these reports generally to the landlord that's screening the prospective tenant. And then you have the furnishers of information. And in the landlord tenant context, those are generally going to be debt collectors. And they're the ones that are feeding this information a lot of times to the consumer reporting agencies. So you guys may have some debt collectors you commonly see in your area, maybe Hunter Warfield, maybe PDM or NCS, a lot of acronyms. And if Hunter Warfield or PDM or NCS or any of these companies are reporting information about your clients to the consumer reporting agencies, they are data furnishers. And they also have some obligations under the Fair Credit Reporting Act. And if those furnishers are debt collectors, you might also have some claims under the FDCPA or the FDCPA. All right, so this is really this is not an exhaustive list at all. You're going to find landlords using any number of companies to do their tenant screening, but these are just some examples of really common ones you might run across. So you've got RealPage, Leasing Desk, RentGrow, Yardi, CoreLogic, and then of course you see here you've got TransUnion Rental Screening Solutions. So one of the interesting things about this industry is, as tenant screening has gotten more pervasive, and most of the data these days says that 90% of landlords are using some sort of tenant screening product. As this tenant screening has gotten more pervasive, it's gotten more lucrative. And this tenant screening right now is a $1 billion plus industry. And so once you have this much money involved, of course, you're starting to see some of the bigger players, some of the traditional big three credit reporting agencies are also getting involved in the tenant screening game. So, this here is just kind of an example of some of the companies you might see. Another important thing to kind of keep in mind as we go through today, we're doing a lot of talking about tenant screening. And so that's sort of at the front end, okay, as your client, as a tenant is applying for a tenancy. But when you're looking at these issues we're talking about today, you really also need to think about back-end issues. issues when the tenant is moving out, because it's all sort of circular. If your client moves out and they owe money, or they allegedly owe money for past due rent, or if they allegedly damaged the property, or if they maybe terminated their lease early and the landlord's including some charges about that, those back end issues eventually become tenant screening issues. And so you really need to look at this holistically. If you are maybe representing a tenant in eviction, you're working out some sort of stipulation or some sort of settlement with the landlord, you need to be thinking about how you can control the collateral consequences of that eviction that's already been filed, of any alleged debt that that landlord is saying your tenant owes, because those back end issues honestly end up becoming tenant screening issues, 90 days, 6 months down the road. Other entities or data sources you might see companies like LexisNexis involved. Okay, a lot of these tenant screening consumer reporting agencies are pulling civil records, court records, public record information from LexisNexis. They also may get this information from what we call court runners. And believe it or not, in places like New York or other big cities, there is still kind of a cottage industry of people that physically go into courthouses, review filings, and manually pull data from court dockets. You might also have other data resellers. And then, of course, as we've talked about before, the credit bureaus, Equifax, Experian, TransUnion, they also generally are supplying at least some of the information that you would see in a typical tenant screening report. All right, so what's included in a common tenant screening report you're going to see? So if those of you haven't seen them before, someone comes in your office and they say, hey, I applied to XYZ landlord and I got turned down. Here's this report they gave me when they denied my application for tenancy. What are you as an advocate going to see there? Generally, the first thing you're going to see is what we call credit header information. And that's just the general kind of identifying information for your client. It's generally going to have names and aliases, maybe date of birth, maybe a middle initial, just kind of that baseline identifying information. And then in most tenant screening reports, you're also going to see a section on criminal history. You're going to see a section on public records. That's where your evictions filings are generally going to show up. And then you may also see information on income or employment. And finally, you're typically going to see what looks like standard credit report information. So things about collection accounts, past due debts, that sort of thing. And really this can all vary. Another important thing to understand about these tenant screening reports is, each landlord is a little bit different and they may be requesting different data from their tenant screening company. So some landlords may want to go back 3 years. Some landlords may want to go back 5 years. Some may say, well, I only want to know about felony convictions. Some may want to know about misdemeanors too. And, typically speaking, these landlords can kind of give their screening company various criteria that they want to know about before the screening company's pulling the report. All right. So it's also important to understand how the screening reports are created, okay? Unlike traditional credit bureaus, which may sort of keep information on your client kind of housed, in some big database on servers, a lot of these tenant screening companies, they don't necessarily always maintain a permanent file on your client. More so what happens is they receive some, so your tenant goes, they apply with the housing provider, they give them a name, date of birth, an address, and then that landlord then gives that basic identifying information to the tenant screening company. And then that tenant screening company is pulling all this information from those various resources we just talked about kind of in real time. So they're saying, okay, here's Adam Thoresen, he's applied for housing. Let's go to LexisNexis and see what public record information is out there. Let's take a quick snapshot of his Experian credit account and see what his delinquencies look like. And then they compile all that information together using usually proprietary sort of algorithms that match up your identity with this information that's out there kind of in the cloud and the ether. And then they compile together this report and they spit out this report to the landlord. One of the interesting things to me that I found out as I started doing this work more and more is that these reports, despite there being lots of laws in the Fair Credit Reporting Act about accuracy, about being reasonable, about matching up this data with the right people, these tenant screening companies are sometimes making these reports in seconds or minutes. And then they're spitting out this information back to the landlord, oftentimes with a recommendation whether to admit or deny that tenant. And so, just because of the way all of this is working behind the scenes, because of the speed with which this is done, you are going to potentially see a lot of errors in your practice. All right, so how do we issue spot some common problems here? What are we really looking for as we're reviewing these tenant screening reports? First one here, bad matches. This to me is probably some of your best cases that you may see. And what I mean by bad matches is that someone else's information is ending up on your client's tenant screening report. Someone else's eviction, someone else's delinquent credit account. Your client may say, hey, I never lived at Shady Oaks. Why is this eviction from Shady Oaks 4 years ago showing up on my report? And what you'll find is that this is, more common, I would say, for people that have common names. So the way that a lot of these companies work is if they're screening for a Michael T. Jones, maybe they're only looking for M.T. Jones. Maybe they're only using the year of the date of birth. Okay, instead of using all of the information that they have from that prospective landlord to match their data, they might take some shortcuts. And this can end up with another M. Jones eviction ending up on your client's report. That's what we mean by bad matches, or sometimes you'll also hear it called a mixed file. Second category of things you want to be looking out for is outdated or incomplete information. And you'll see on the slide here, the very next bullet point is obsolete information. And outdated information is different than obsolete information. So when I talk about obsolete information, at least for purposes of the Fair Credit Reporting Act, that's generally going to be non-criminal convictions that are older than 7 years. And with some exceptions, there's a broad prohibition on these consumer reporting agencies reporting any adverse information, negative information about your clients that's older than 7 years, that's not a criminal conviction. And so in the Fair Credit Reporting world, we would call that obsolete information. But this kind of outdated or incomplete information is a little bit different. And that would be more so the example of, a hot topic, at least for us lately, for legal aid housing attorneys, is maybe sealing or making an eviction record confidential. And an example of outdated information would be that even though you've helped your client make this eviction judgment or eviction record from a few years ago confidential, that it's still showing up on a tenant screening report. And usually that's going to be because the data pool that the tenant screening company is pulling this information from has not been updated in a while. You know, maybe LexisNexis hasn't scraped the Duval County public records in 4 months. And so they don't know that this judgment that used to appear has now been made confidential and now should no longer be showing up on a tenant report. So that's a good example of outdated information, incomplete information, or misleading information, which is the last slide. Might be something where the eviction is showing a judgment entered, but really the case was dismissed. Another example that I see commonly is an eviction is being called an unlawful detainer. And for, you know, those of us, obviously we practice in Florida, you know, we understand that a Chapter 83 eviction is different than an unlawful detainer action. But in some parts of the country, those terms are sort of used interchangeably. And, you know, I think the elements of the claim are different. I think the implications of unlawfully detaining your property from somebody versus being evicted are different. And so I would argue that if your client comes to you with a tenant screening report that is saying they unlawfully detained or forcibly entered a property versus an eviction, which is what it really was, if that tenant screening report is saying it's an unlawful detainer, I'd say that that's misleading, okay? And that's potentially actionable under the Fair Credit Reporting Act. Okay, so moving on here, you know, one of the big challenges a lot of times for us as practitioners in this particular area is that, you know, we'll have a client come to us and they'll say, you know, I was turned down for housing and they just sent me an email and they said I was denied, or I got a phone call from the property manager and she said I was denied. And, you know, maybe even the property manager gives them a little bit of detail and says it was because of an eviction or something like that. But, you know, in order to have these Fair Credit Reporting Act claims, we really need to be able to see the report. And we need to know where that report came from. So one of the important things to know is that there are two kind of sections under the Fair Credit Reporting Act that do require landlords or users of reports or employers to let a consumer know where this information came from. And those are broadly called adverse action notices, okay? And landlords are actually required to give a tenant that they reject a post-adverse action notice. That post-adverse action notice generally is going to say on it where this landlord pulled the information from. So if your client happens to come to you with an adverse action notice, that's really easy to find out where the info came from. You just look on the notice. It'll say, hey, we got this from Yardi or we got this from RealPage. And then you can actually help your client do a file request to RealPage or Yardi and get a copy of that report. You know, however, if your tenant, you know, again, is in the scenario where they just come in and say, hey, I got a phone call, you may have to advise your client, hey, go back to the landlord, you know, ask them where they got the report from. Ask them if they'll give you, ask the landlord if they'll give you a copy of the report. And, you know, sometimes the landlords will follow through here. Two important things. Do you have something, Christy?
Yes, just some quick clarification questions. Sure. What did you say about evictions that came to an agreement?
Oh, right. So, you know, one of the things that I've seen on occasion is that an eviction is actually being reported as a judgment. So when I'm looking at the tenant screening report, I'm looking down in it and it says, you know, your client's name, it's got the date that the eviction was filed, and then maybe it has a judgment date. Okay. And so if a landlord was looking at this, the report appears that the tenant was evicted. But when I'll actually go through and I look at the court records and I cross-reference that same case number, I will see that there was actually a stipulation between the landlord and the tenant, and that as long as the tenant, let's say, moved by a certain date or paid some certain sum by a certain date, that the eviction is supposed to be dismissed. And I'll talk to the client and they'll say, oh yeah, I've got the receipt where I turned in my keys, on or before that date. And it come to find out the landlord just never dismissed the eviction. And nevertheless, that screening report is saying that there was a judgment and there was never a judgment entered.
Okay.
So that was kind of just an example of something you may see.
Along the same lines, we had a request to please go over the obsolete information again.
Absolutely. So obsolete information, and we'll talk about this a little more in depth as we move through the slides, but there's a prohibition in the Fair Credit Reporting Act for a consumer reporting agency to report non-criminal convictions that are older than 7 years. And there are some exceptions to that, but generally speaking, alarm bells should be going off in your head if you're seeing negative information about your client in a tenant screening report that is more than 7 years old. And that would be an example of obsolete information. Anything to add to that, Austin?
No, that would be, I would say, even the eviction you spoke about, where an eviction had been filed, but it was dismissed or settled, could be considered obsolete information. And then anything too, I could see someone gets married, they change their name, something like that, and then it becomes an issue because it's matched up with a different name. Really obsolete, just inaccurate. The biggest thing is inaccurate for people to remember.
Absolutely. Those are good tips. Real quick before we move on, just some points of caution here. There are some citations throughout the slide to various sections of the Fair Credit Reporting Act, which is 15 USC 1681. Just be aware some of these are not privately enforceable. In other words, the CFPB or the FTC has sole enforcement authority. And so you wouldn't necessarily want to read through the statute, think that a landlord or a CRA has violated that part of the statute and unwittingly file a case for something that's not privately enforceable. A good example of this is this 1681M that's on this slide, on the slide here. Even though a landlord is required to provide these post-adverse action notices, most of the appellate courts have said that is not privately enforceable by a consumer. But I will say there's been a lot of meetings with the kind of new regime at the CFPB, and they are very interested in enforcement actions related to landlords not providing tenants post-adverse action notices. And remember, again, a post-adverse action notice is where the tenant has been denied or some other adverse action has been taken, an increased deposit or something of that nature. The landlord's required to give that notice to the tenant. And so if you have landlords in your jurisdiction that aren't doing that, especially if they're larger landlords, you may want to consider having your clients file complaints with the CFPB. One final thing to note is these credit bureaus or any nationwide credit bureau is required to give a free report to your client upon request. The old rule is it used to be once per year from each of the 3 bureaus. However, because of some of the CARES Act provisions, some of you might not know your tenants are entitled to a free report once per month from now through April of 2022. So have your clients take advantage of that. They can actually request their file disclosure through 1681G, and they can do that once per month due to the CARES Act. So it's a great tip. This is a little hard to read. I apologize. Hopefully when we distribute the materials, you can see it better. It's just a kind of a picture of what a sample screening report might look like. You see here up at the top, just basic ID information. Then as you move through the report, you've got your criminal histories, you've got your judgment histories, etc. All right, what are common claims? I'm not going to spend too much time on this because I'd rather get into it through the hypos that Austin is going to talk about. But I tried to highlight some provisions of the Fair Credit Reporting Act that are going to commonly be applicable to tenant screening. So you've got 1681 EB. You'll hear this called an EB claim. And that basically is applicable to CRAs. And it says that they need to have reasonable procedures in place to ensure maximum possible accuracy. And that is actually the statutory duty. That's the duty that's imposed to them by the case law, is maximum possible accuracy. And you'll remember what I talked about earlier is that a lot of these companies are only using maybe a first initial partial date of birth. Is there any way that in this day of age we think that using partial data matching is maximum possible accuracy? Probably not. And when you see one of these mixed files or bad matching cases where someone else's eviction has ended up on your client's screening report, that's probably a good example of an EB claim. More than likely that CRA is not using reasonable procedures to ensure maximum accuracy. 1681I, that's easy way to remember that, I, investigation. That section applies to CRAs, and it says that if your tenant, your client writes in and disputes some information that is showing up on a tenant screening report, that CRA needs to conduct a reinvestigation of that dispute. 1681G, this is the file disclosures that I just talked about. Sometimes you'll have a CRA that's non-responsive, that doesn't actually provide the file disclosure, and that may be actionable. 1681S2B, this is also investigation claims, but unlike 1681I, which applies to CRAs, which I noted there, 1681S2B applies to furnishers. So remember I said earlier on in this that these various landlord-tenant debt collectors may be data furnishers, and they've got some obligations and duties under the FCRA as well. They also need to conduct a reasonable investigation when your client submits a dispute. And then 1681C, this applies to the obsolete information. So again, if your client comes in with adverse info, it's older than 7 years, you may have an obsolescence claim. So here's the good stuff. What are the damages if we think we've got an FCRA violation? One of the things you'll notice here, for both willful and negligent violations, you can get attorney's fees. The most important distinction really is that for a negligent violation, you've got to be able to show some actual damages. Whereas if you can prove a willful violation, you can get statutory damages. So the statutory damages range from $100 to $1,000. And for those of you that do consumer law, it's kind of similar to the $1,000 statutory damages available under the FDCPA or the FCCPA. Another great thing with these willful violations, you can get punitives. So if you can, show maybe that your client disputed over and over again 3, 4, 5 times, put this CRA on notice that this eviction belonged to someone else, and that CRA kept verifying that information is accurate, and you've got some housing turndowns maybe, that could be a good punitive damages claim. The next few slides, which admittedly I'm going to kind of power through here, are showing you the elements that you're going to need to prove these claims. And the most important thing, if you don't take away anything else from what Austin and I talk about today or this training, I want you to think about two things with these FCRA claims. One, you need an objective inaccuracy, okay? You're really looking for something that an outside observer would say is objectively inaccurate. You don't want your tenant just saying, well, I disagree with this, or you don't really want it being something that's open to too much interpretation. So one is objective inaccuracy. Two is dispute, dispute, dispute. The more disputes, the better. I'm going to be honest with you. For some of these sections of the FCRA, you don't actually have to have a dispute. For some of them, before you can even file a case, you do have to have a dispute. Austin may disagree with me here. I'm generally disputing no matter what, because I just think if the dispute works and the CRA fixes it, great. Now you've helped your client, you've helped them clean up their record, they can rent housing. And if it's not fixed, now you're just kind of increasing the value of your claim. So I tend to dispute always. Have my client dispute always, at least. So you, for these EB claims, you want an objective inaccuracy. Publication's important here. That really just means someone has to have seen this inaccurate report. Pretty easy to do in the tenant screening realm because that landlord has almost always seen the report. 3, you're going to want damages. Some of the damages you might see would be some landlords require an increased deposit if the tenant has excessive derogatory information. Obviously, getting turned down or denied for housing is great damages. Some landlords even have like sliding rent scales based on creditworthiness. So obviously you're going to want to be able to show some damages caused by the violation. 1681C, again, this is just obsolescence. Kind of beat that one into the ground. You're just looking for non-convictions that are older than 7 years. I've listed some of the exceptions here. These are just examples. One other thing to look out for, though, is, I'm telling you that criminal convictions can be on there longer than 7 years. But, make sure if you're looking at a charge that appears to be a criminal matter, make sure it's not really just a civil violation or a traffic violation, especially if it's older than 7 years, because that may need to come off. It's not a true criminal conviction. Certain traffic citations, open container, something like that, might just be a civil violation. 1681I, these investigation claims, and this is the same for the S2B investigation claims. These are some of the ones that you have to have a dispute, right? Your cause of action is going to be because the CRA or the furnisher didn't reasonably investigate the dispute. Well, you can't trigger that duty to investigate without actually having that dispute first. Very common question here is, well, who should be doing the dispute? I think absolutely the disputes should be coming from your client. I'm of the personal opinion that the lawyer can help the client draft that dispute. I don't have a problem with that. Some lawyers fully ghostwrite them, have the client review, make sure everything's accurate and signed. Some have the client do a first draft, then the lawyer kind of helps them clean it up. But I think they should come from the client. They should be signed by the client. Here, S2B, this is very similar to the slide before that, which was the I claim. Again, you need a dispute. One common pitfall for these 1681 S2B, you'll remember I said this applied to furnishers. So the knee-jerk reaction for some advocates or some consumers is, well, I'm going to send the dispute then to the debt collector. I'm going to send it to PDM or Hunter Warfield or NCS. Send it to where the bad information is coming from, but you don't actually trigger a furnisher's duty under S2B unless the dispute goes through the CRA. Okay, it's got to go through the consumer reporting agency. So I made a note on this slide that it's very important that your client, they can send one to the furnisher if they want to, right? They can CC the furnisher, which I typically have them do, but that dispute is only effective for an S2B claim if it goes to the credit reporting agency. And again, what's going to trigger the liability is if they fail to conduct a reasonable investigation. And what's reasonable is going to be very fact specific, but they're going to have to, I always encourage my clients to attach whatever supporting documents they have to the dispute. Maybe it's actually the disposition from the court docket, or a printout of the docket itself, or maybe a ledger showing that they paid off everything they owed. They've got to review all of that supporting documentation your client submits with the dispute in order for that dispute to be reasonable. All right, so with that, I'm going to turn it over to Austin.
Thank you very much, Adam, and thanks for the overview of the FCRA and all the kind of details there. I'm Austin Griffin, like we said at the beginning, and I'm going to go through a few case hypotheticals, a few of the more the practical side of this, and we'll answer questions at the end. But because we're running a little short on time, I'm going to give kind of a broad overview and kind of some of the the issue spotting of these hypotheticals, but obviously all of them will be different, and it's just good to have an idea of the basics when you go through with some of these client calls. So let's start with case hypothetical number one. Potential client, Timothy Michael Kelly, Mr. Kelly, applies for an apartment, paying the eviction fee, the application fee, and touring the unit. All that's left is a background and tenant screening check. A few days later, he received an email from the property manager denying his application based on derogatory information contained in the background check. Lo and behold, he gets a copy of the background check showing that he's listed as a sex offender in Virginia and Pennsylvania with 4 prior felony convictions for sex offenses and failing to register as a violent offender. Mr. Kelly is distraught and tells you that the records don't belong to him. His full name, of course, is Timothy Michael Kelly, date of birth May 4th, 1980, and from Hartford, Connecticut. You obtain the underlying court records which show the name of the defendant, Timothy Matthew Kelly, date of birth March 30th, 1980, and address in the custody of, I'm assuming, Virginia or Pennsylvania. So this is actually relatively common, which is uncomfortable, that criminal records with similar names will get mixed in. It's called a mixed file. And basically, best thing to do is kind of break it down. First of all, I always ask, okay, what's inaccurate here? What's the problem? The client will say, well, obviously, I'm not a sex offender. That's a pretty good inaccuracy. And then who are we looking at to sue, and what are the claims? Well, right off the bat, I would say with a mixed file, anybody reporting it, it's usually the credit reporting agency or the consumer reporting company is going to be mixing the file. It's rare that the furnisher of information is mixing it, which would be the underlying, I guess in this case, it'd be the court system. If that's happening, you have a whole another issue. But I would start with breaking those down. So you're looking at a possible Fair Credit Reporting Act case against a credit reporting agency. So you'd want to do a dispute explaining that, hey, this isn't my information, this isn't my name, it's not my date of birth. And then from there, you would get something along the lines of like an investigation claim, like we talked about before, against the CRA. If they fail to fix it, of course, you file suit. If they do fix it and there's a time period between a couple disputes, you can still file a claim under the FCRA for improper investigation between the first dispute and whenever the dispute was that fixed it. Our firm usually files, or at least usually does 2 disputes per case, because we allow for that time period before filing suit, or even before it gets fixed, to be an FCRA claim. With the timing, well, first of all, with the benefits of the dispute, like Adam mentioned, because everyone on here for the most part is working legal aid, the idea is to fix the problem. Obviously, there are benefits to getting attorney's fees and everything, but because the dispute process can easily take months, the CARES Act that gives you the additional consumer reports also gave them double the amount of time to respond to disputes. So that's kind of annoying. And we've actually found that they're taking, and by they, I mean consumer reporting agencies, consumer reporting companies, furnishers, are taking not only 2 months, but up to 3 months to respond to one dispute. And so you want to get on the dispute process as soon as possible after retaining the client. So the benefits are fixing that problem for them quickly. And then by failure to fix it, if after the first dispute and during the period between the first dispute and any time after until it gets fixed, prior to suit or even during the litigation process, they might have, it's called publication to third parties as a claim, that if anyone else pulls the tenant screening record, background check record, credit reporting record, which some of them, especially like LexisNexis and some of those companies that are very broad in what they provide for personal information, if anyone is pulling that information, any third party, including a bank, employment, even things like, I think Disney Vacation Club will pull to make sure none of that information's on there. You want to go ahead and possibly do a third party pull claim, also called permissible pull, or the third party publication, like I mentioned before, because anytime they're providing that information they know is inaccurate, that is in of itself an FCRA claim and could be additional damages. So I think what we're really looking at with this is going to be a pretty pure FCRA inaccuracy claim. And Adam, jump in whenever you think if there's anything else. It's not really debt collection. It's not really, you can't blame it on the landlord, because if it is a common background screening company, they have no reason to assume it's inaccurate until you tell them. But even then, I think that's more of a damages issue than it is a claim against the landlord or property manager. So that's the first one. I went through a little quicker, so well, I'll answer any questions as needed. But do you see anything on here?
No, I just, I think it's important just to note, when you end up filing these cases and you get a defense attorney in there, and, they're always going to be making the argument that, that they're have a 99% accuracy rate and their procedures are reasonable. But, this fact pattern kind of presents just some of the common arguments you can make to show them, no, it's just patently unreasonable. They knew that our client's full name was Timothy Michael Kelly, yet they put information about a Timothy Matthew Kelly on his background report. They knew that our Timothy Michael Kelly lived in Hartford, Connecticut, and was a free man who was applying for housing, yet the sex offender that they included on his background report was in custody. And also they knew that the date of births were completely different despite just the years matching. And so the more you have these kind of little pieces that you can show them, hey, and I always try to show them on their own report. Your own report has all these extra pieces of information about both people. You had access to this, yet you still merged these files. And that's just good to point out to defense counsel.
Oh, absolutely. And something I actually want to add on that, in my experience, at least with the credit reporting agencies, they require at least 3 personal identifiers to match a file. So I noticed there was a complete lack of social security number, which makes no sense to me at all. There almost always is. And the fact that the name doesn't totally match up, the birth date doesn't, and that I'm assuming the social security number wouldn't match up, that's going to be an even better case. So you always want to focus on those 3. The housing addresses are important, but I'll get into that with another case because that's more of an identity theft issue. And so for the case hypothetical number 2, plaintiff Miss Johnson had an eviction filed against her by a landlord for non-payment of rent for 2 months. The eviction was filed and served, but she and her landlord were able to work out a settlement. This is a similar case to what Adam was talking about earlier. And the eviction was dismissed voluntarily. and she moved out with no issue at the end of her lease term. And then she went on to go to a new apartment complex. Well, the property manager ran her tenant screen report through Nexus Lexus, not to be confused with any other companies, living or dead, and finding that she had been evicted from her old apartment. Information on the report was shown as follows: eviction, August 2019, Duval County, Florida. And actually, this is very common to have sort of the court records and very bare minimum information on it. Obviously, they denied the apartment rental for Ms. Johnson having a recent eviction on her screening report. She tried to explain the property manager was incomplete, and she'd settled. And of course, the property manager refused to hear it. And you're going to see that, especially right now in places like Tampa and Jacksonville, such volatile housing markets. They're just going on to the next one. Now, Ms. Johnson is having difficulties finding a place. It's eviction list in our consumer report. Comes to your office, having already disputed once with the screening company. I'm assuming probably by a telephone dispute, which all of your clients can do. They can call into basically any of these companies and make an official dispute via telephone. But we recommend having, the timestamp and everything of when that happened to go later when you go back to the account notes. But they are a legitimate dispute. It doesn't have to just be through a letter. It can be online. It can be over the phone. Even, I think there's some apps for it now. Credit Karma has some of that, although I'll get into Credit Karma, but that's always the best choice. But anyway, let's go through the claims here. You can go to the next slide if you want to. So first of all, there's a clear obsolete information issue here. So she's already made one dispute. And as we talked before, that the eviction never really happened. So it's an incomplete, misleading bit of information, and there'd be, maximum accuracy is not there. It's technically inaccurate. Is there a claim against the property manager? No, I don't think there is. And I wouldn't even necessarily say there's a claim against the landlord. The landlord was doing everything that they were trying to do right. They settled the eviction. And even though the information was furnished by the landlord, it was really gotten from the courts here. So I think, again, you're only really looking at the credit reporting agency or the consumer reporting agency in the form of this Nexus Lexus company. Would you want to do additional disputes? I would say yes. I'm with Adam that I think at least a couple disputes is important. We generally speaking, do ghostwrite a lot of disputes, and we have the clients review it as opposed to them writing it just themselves. The fact that it was already a telephone dispute is good. As long as you have record of that. Some companies will even email you afterwards, ask for your email, and I think Experian and Equifax are really good about that, or for online disputes. But you would want to do another dispute and wait to see if they fix it. And then after that, after the second dispute comes up and you pull the report again, you'll have to pull multiple reports every time a dispute is made, because even if they don't respond to you from the dispute, they may have updated the information on the report. That's an issue we're seeing more and more. These consumer reporting companies aren't actually responding to the dispute letter, but they just fix it anyway, I guess out of annoyance. I'm not sure exactly. But then after that, yes, you're clear to file at least a Fair Credit Reporting claim. You can't really file, something we sort of mentioned, but it bears actually, I don't know if we did mention it, but the fact that slander and libel on consumer reports, because some clients may say, hey, they're slandering me, this isn't true. It sort of is slander and libel, but there's actually a provision in the Fair Credit Reporting Act that if it's a consumer report, it abrogates the slander and libel state claims if it fits under the Fair Credit Reporting Act. So that's something to, even though people go, well, this is fraud, this is misinformation. It is, but really you're going to have to file under Fair Credit Reporting. And if that doesn't work out, then you can move forward with the state claims. Although there may be in California, and I think this is everybody's just in Florida here, but some other states have those claims. Florida doesn't. We have good debt collection laws, but we're not really at this point yet. So I think it's basically FCRA, unless Adam, do you see anything else too?
No, I just question for you. Let's say the CRA doesn't fix it after the first dispute. and then maybe you dispute 2 or 3 more times and they eventually do correct the information, would you still file a case like that once the information's been corrected?
Absolutely, I would. It would not be a big case. And there's a few reasons why to do this. One, they still created a problem for the client, for the consumer, for the few months, or I mean, we've had it where it's been like 3 years. So you have that publication damages where it's going to third parties. It's kind of publication claim. And anyone who's looking at that background check saying that she had an eviction, and it's going to be, I'm sure after her dispute, she's going to still try to find an apartment to live in. That's still good damages. And something to mention about damages, we'll get into a little later too if we have time, but actual damages under the FCRA aren't like personal injury or anything. You don't have to have medical bills. There's something called garden variety emotional distress and credit reputation damages, which are actually really well documented in the case law, that you don't, just being irritated and upset about this bad information is enough to get actual damages under Fair Credit Reporting. So publication is important to a third party. It's not vital. As long as you have some sort of damage, then you have enough. And actually, there's some good federal cases we'll be able to maybe provide with the email after this. I'll find a couple. But I absolutely would sue. And it's important to do this too, just from a public perspective, that by suing these companies to go, well, it's not a big deal, we fixed it. You want to make sure, you want to have the carrot and the stick. It's not a big damages case, but they need to know not to do this. And if people are actually going out suing them, because a lot of these companies are not sued for this sort of issue, especially not landlords and property management companies, that they'll fix their systems at least a little bit over time, so you don't have to keep having these calls. These people aren't having these issues. I mean, the idea is this is public justice. We want these problems to be fixed ultimately. I prefer to be out of a job and everything working than to be too busy.
Yep,
So,
that's good. That's good information, and I would file that case too. So I agree with you.
Went off on a rant there. I'm sorry.
Yeah.
Oh boy, we are running out of time. So, and I apologize. I wrote this hypothetical, so if anyone's looking at me a little funny, it is Lord of the Rings theme. But I want to go through pretty quickly. This happens a lot. So Frodo leaves the Shire. He ends his lease term early with Bilbo Baggins, and he goes ahead. There's a liquidated damages claim. We see those a lot in the leases. And so he owes $3,000 on move out. We're assuming Bilbo did the proper security deposit, notice letter and everything. That's fine. He makes his first payment. Frodo does. Then he gets kind of lost on this trip. Read about it. Don't worry about it. And he loses track of his payment arrangement. So after 2 months of non-payment, Bilbo, like many landlords or property managers, is going to go ahead and hire a debt collection agency. We mentioned before, NCS, PDM, and Hunter Warfield are very common, to collect the final rental debt of $2,000 that he still owes. So the problem is this company has a history of tacking on extra fees. And so they go ahead and charge 2 months of late fees on this debt of $200, and then places it on Frodo's credit report. So not his tenant screen report, not his background report, but his regular credit report. So all of a sudden pops up after a couple months, $2,200 on his Equifax and TransUnion report. He pulls it up on Credit Karma or something to take a look at it. And he tries disputing the charge with this debt collection company, Smauging Company. But of course they verify it, which happens a lot. They say, oh no, in our record, this is how much you owe, therefore. And he's not reached out to his landlord yet. And it's interesting, on his credit report, it doesn't show his landlord, it just shows Smauging Company. And it may say that, it's a landlord-tenant debt or a leasing debt or something like that, but it's usually not, it doesn't list the original landlord. So just before calling your office too, he clicks dispute on Credit Karma, but there's no results yet. So in this instance, go ahead. Should you do additional disputes? Should we sue? What claims does this present? Well, this was a little more interesting because there's a few more things going on here. First of all, should he dispute again? Absolutely. Credit Karma is a third-party reseller. Most of those apps through, I think, Chase Bank, I think Deutsche Bank has one, Wells Fargo does. They provide your credit information, but it's never a complete picture. The best thing we recommend doing is going on annualcreditreport.com. That is the federal website. That's the one protected by the CARES Act and, subject to the, I think it's actually once weekly credit reports until April of this year. That might get extended. I think people are really liking it. But if not, it becomes monthly. I think that's the rule. And perfect. Thank you very much, Christy. That's exactly the website. So you want to pull all three real credit reports from Equifax, Experian, TransUnion. If they don't want to give it to you because for some reason they don't, Experian and Equifax have been especially bad about that recently, even after providing all the information. There's a paper form. You can actually get your report in 2 weeks. You don't have to sign it. I don't know why they thought that was okay, because you're putting all your personal information down on a piece of paper and mailing it off to some address, and I guess that's all right. But you want to get the full credit reports first before you do an additional dispute, because you want to see if there's anything else wrong on that account. When that's done, you're going to dispute with the debt collector, who's the furnisher in this case, through as many credit bureaus as it appears on. Once you've done that, they fail to fix it, you actually have a few claims here. First of all, you have FCRA claims for improper investigation if it's not fixed for all three credit bureaus, or all credit bureaus who are still reporting it, and with the debt collector, Smalgam Company or whoever. You don't still have one with the landlord unless they included an improper late fee, but that's a whole other issue. Then you also have improper debt collection from the debt collector, and under the FCCPA, the Florida Consumer Collections Practices Act. I love that law. It's very clear. It's just anything that's, abusive or harassing. It's a very broad category. But I take a look at that. That's Florida statute 559.55, then everything after it. So you'll take a look at that. And then the FDCPA, which is the Fair Debt Collection Practices Act, only applies to third-party debt collectors, which would be the debt collector here. So you can't apply it to the landlord. But you can stack those claims, and they're wonderful for that, because each one of those claims, if you remember correctly, is all attorney's fees getting provided. So I love that. So even if you have one of those dismissed, then you should still be good to go. And even if your FCRA stuff gets fixed, you still have debt collection claims. And I would bring them because it'll stop the company. It'll do a couple things. It'll stop the company from continuing to charge those fees, ideally, and you actually might get the debt wiped out as part of a settlement agreement. So then good old Frodo, your client, doesn't have to worry about paying that, because they'll try to claim set off. Set off is not a defense. That's wiping out the debt. Like, oh, well, no debt, you don't have a claim. That's not a defense to most consumer laws, certainly not FCCPA. But they may wipe it out as part of a settlement, and then you get your reasonable attorney's fees. So generally speaking, I think with all these cases, I would say sue, and then do an additional dispute, but make sure you have not Credit Karma, but a full, real credit report. That's vitally important right now, especially with how these apps are changing the credit bureaus they rely on for their information. And then they kind of add their own little twist on things, which is, not accurate. But anything you want to add to that, Adam?
No, I like that tip about Credit Karma. I mean, I think it's a great tool for our clients to monitor kind of what's going on with their credit in real time. And often a Credit Karma alert might be the way they discover something is amiss. But I agree with you. You really need the true blue reports directly from the bureaus for these cases.
Yeah, perfect. And I think after this, I've got a couple basic pitfalls and practical tips. So this is interesting because, this has some of the stuff I'm already listing, but the biggest thing, especially for kind of an institutional firm, a legal aid firm of one kind or another, this is all about time. Unfortunately, these cases are slow-moving claims in fast-changing circumstances. Your client, the reason they came to you is because they need a place to live, and they cannot currently live anywhere because of what's on their report. Your focus should be disputing first, And then if not, then bring the hammer down, then file suit. But your folks do understand that these disputes, they will take months. Some of them take a lot faster, but unfortunately, especially right now with a lot of these companies still working from home partially, and the information's all kind of dispersed, and it's a mess. It's a mess with the dispute process. We've noticed this, but time is going to be of the essence. And also with the housing markets in Florida being so volatile right now, but the number 2 housing markets in the country are Tampa and Jacksonville. So with housing and rent prices going up, especially for low-income clients that you're helping out through legal aid, you may need something to work with the city or with the Federal Trade Commission or CFPB, get them on speed dial so that you can help them to find housing while this is going on, because it may take longer than they have to find housing. And that's something I'm really concerned about. Also, another pitfall, your defense counsel. A lot of the attorneys, especially with landlords and property management, that get hired in these cases are the same attorneys that they hire for evictions. So they're not necessarily in tune with the subtleties, kind of the narrow issues in a Fair Credit Reporting Act case. They may not be familiar with the federal rules. And usually in that instance, what's the rule? If you have the facts, pound on the facts, you have the law, pound on the law. If you have neither, pound on the table. It's a lot of table pounding we've noticed recently. And that can drive stuff kind of into a rut, make it a lot slower too. So you can't control that, but just be aware that the cases might be slow because some defense counsel may not be used to this area. The ones who are used to this area, Jones Day, let me think, King and Spalding, some of these with Equifax, Experian, TransUnion, they have kind of their own in-house. They're actually great. We've liked working with them. I mean, it's an attorney by attorney basis, but they can move forward a lot faster, and it'll be easier to get your client's problems fixed. So just something to keep in mind. As for practical advice, it's in here. Relevant underlying criminal records and eviction records, but the consumer's full file. You get as many documents as you can. Get copies of everything. If the landlord or property manager wants to give you copies, get them. Full lease with all the addendums, get it. Because you want to prove inaccuracy, more or less, in your complaint, and in your dispute, because it'll be so much harder for them to defend against it. Again, as much as you possibly can. If you think there might be an identity theft case, which we've had happen with evictions, someone went in on someone else's name with a fake ID, and sure enough, it became identity theft claim. You're going to want to get a police report. It doesn't matter if they think they know the people. You need that police report. You need the identity theft affidavit with the Federal Trade Commission. And again, those are great because they're all free, and it's all just one more thing for your client to do, so you can busy them while you're waiting on the dispute responses. And then that also just kind of comes together. So those are important. And make sure you get tracking information, usually through certified mail, if you're going to do a mail dispute. I love those little green cards because we have a lot of credit bureaus and other consumer reporting agencies come up and say, oh, well, we didn't get that. That's not in our file. You sent to the wrong place. And I hold up a green card. I go, isn't this your address and your employee? And didn't they just sign that? Those are wonderfully useful. And again, it just shortens the time you're in litigation. If you have all the information up front, they're more likely just go ahead and settle. There's not a lot of very few of these companies, at least the credit reporting companies, are trying to make a philosophical point. They're usually just trying to, clean up damage and risk assessment. As for that, I would also say litigation tips. Like I said before, actual damages in Fair Credit Reporting Act are very, very broad. Any expense, any garden variety emotional damage, we usually say damages between relationships of family members living in an apartment. Like what if, for instance, they have a couple children, they're in a 2-bedroom apartment, whatever. Now they got evicted, or they're trying to get a new place. Well, the kids can't go to school in the district they were going to because they went to a new district because the they couldn't get a housing there, and they miss all their friends. That could be considered damages. very broad, but that's very useful. So think outside the box there when you get into litigation. Also, this is very important, scan everything. I don't care if it was, just a slip of paper that your client gave you with a phone number on it, put it in the system, because I know I lose things all the time. And we have paper and electronic files, even some stuff on Google Drive, but scan everything, vitally important. And of course, consider every possible defendant. That's important because it may not just be the landlord, it may not just be the furnisher. You may have 6, 7 defendants if it went through a couple debt collection companies, if a debt collection law firm filed suit against your client but had the wrong name on file. We've had that happen twice. It's a lot of fun, but yeah, how to put this nicely, no one's safe, and it's much easier to dismiss than it is to amend, especially with the federal rules are tightening on the amount of time you can amend the deadlines. So just keep that in mind. But I think, yeah, that's basically what I have for my litigation tips and anything. Adam, do you want to add anything?
No, I think those are all great, and especially your first point. Just with you saying it's taking up to 90 days maybe per dispute. I think one of the most important things we can do as legal aid lawyers is client control from the beginning and setting their expectations reasonably. And it's going to be a very important issue to them because, like you said, they're out there trying to get housing, they're sleeping on a couch. But you just have to have that honest conversation with your client about the limits of what you can do, how long it's going to take, how long the civil lawsuit is going to take. And I just think that makes your life happier throughout the process of the case, and it makes the tenant happier.
Absolutely.
Thank you both, Adam and Austin. That was fascinating and terrifying, just to see how much information is out there at a landlord's fingertips with the wrong name. Maybe it makes me happy to have a weird name. That probably won't happen to me.
Absolutely.
But a great presentation. And I do want to remind everyone the recording will go out tomorrow along with PowerPoint and any other notes or resources that our speakers might send to me today. I apologize. I don't know why the CLE is taking so long to be approved. It will eventually be approved, and I'll make sure to get it out to everybody. I don't see any questions. I think we answered them as we went. So thank you both so much for a great presentation. I really appreciate it.
Yeah, thank you, Christy. And I've got Austin and my contact information there. Feel free to reach out to us with questions or cases you see. We're both always happy to talk.
Absolutely. And just so everyone knows too, something our firm is doing as a private firm is partnering more and more on these FCRA cases, kind of weirder federal cases, as just co-counsel. I mean, we're happy to run with certain Fair Credit Reporting Act stuff if it gets particularly weird, or even some class actions. I know Adam and I are working together on a couple landlord-tenant class actions. So feel free to reach out to private attorneys in your area, and we're always happy to talk and help and direct you as best we can too.
We got lots of compliments in the chat, so I hope you guys can both see that. Thank you again. I hope everyone has a great afternoon.
Thank you.
Bye-bye.
Have a good one.